Morning, Judge.
Hi.
I just want the one thing I'll say. I have my client here on video. He can identify himself if necessary. I'm gonna just put my camera on. So
This is a first for me.
It's a first for the ICE supervisor I just spoke to as well.
Wow. Wow. Mr. Feldman, that's some good work, man.
I'm an
Great job.
immigration attorney, Judge. So I mean, and I'm a salaried employee.
Yeah.
Really great job.
Well, I just mean if I wasn't a salaried employee, maybe it wouldn't be worth my time.
Right away, you can tell this isn't a normal hearing. The judge is confused. The lawyers are improvising. And the defendant isn't even physically in the courtroom. This is what happens when criminal law and immigration law collide. Suddenly, nobody's fully in control anymore.
Today is December 10th, 2024. It's approximately 9:44 in the morning. Parties, I'd like you to announce yourselves for purposes of the record, please. Beginning with state.
ADA Rojette Saba and ADA Kelsey Siegler here for the state.
And this is Noah Feldman on behalf of the defendant Cesar Moises Perez.
Okay. You requested this hearing, so I'm going to let you start.
Okay, Judge. Well, before I start, I have 10 exhibits. I sent it to the chief last night, and I believe she forwarded it to Ms. Saba. I moved to admit those exhibits, tender them to the state for any objection.
And Your Honor, we would need significant time to look over these because we haven't been able to do so since they were.
Yeah, I have 10 exhibits. It's quite a bit.
Judge,
I get.
if I may. The first exhibit is the ICE detainer. It was in Harris County possession. The second exhibit is the magistrate order in which the state requested an $1,000 bond, which my client posted. The third exhibit is basically an ICE form you can get off the internet. It's a stay of removal form that ICE allows people with final orders of removal to apply for stays of removal that allow them to stay in the country for a limited time and limited purpose. So what I just offer this to show that.
Is this his, or is this just a generic one?
Generic.
Okay.
Exhibit 4 is going to be just proof that he's in ICE custody. It's a print off the ICE.
That's 4.
Exhibit 4.
Okay.
Exhibit 5 is the bond condition violation report. Exhibit 6 is from the DA portal, just showing the release time from the jail to prove that he was released to ICE. Exhibit 7 is the cash bond that defendant's wife posted. Exhibit 8, to be honest, is unnecessary.
Okay.
Could withdraw Exhibit 8. Exhibit 9 is a sample order of supervision you can get off the internet. It's just standard ICE form. And Exhibit 10 are this court's procedures that are available on its website about failure to appear and non-appearance. Those are the 10 exhibits.
So for purposes of the defendant, so record, I want to make it clear that Mr. Feldman has his computer, and it looks like I can see the defendant there, and it looks like he can look at us as well, but there's no translator, so does he understand what's going on?
That is correct, Judge. I do not believe he understands what is going on.
So now, state, how do you respond to the exhibits?
Judge, I did not get these exhibits until my chief forwarded them to me while I was in docket earlier this morning. I'm going to need time to review these. I'm not an immigration attorney, so I'm unfamiliar with these documents. I would ask for at least a day just to, or I mean, if you don't want to roll it to tomorrow, just like an hour or so I can read through it.
Sure.
And honestly, this becomes less about guilt and more about bureaucracy. One system says he can bond out. Another system grabs him anyway. Now the court is stuck asking a bizarre question. How do you force someone to appear in court when another government agency already took them away?
Sure, of course.
And we did speak, or
I spoke to the ICE supervisor, Judge, the one handling his ICE case. His name is Jeff Hudson. I relayed defense's requests for an order of supervision, and the officer said, he declined the request. He said that there would be no way that they would release defendant given that he is a flight risk and his assault charge makes him a community risk as well. He also advised that the defendant has been deported before. He advised that the only way to get the defendant over to this court is if you issue a bench warrant, and then they would review that warrant and decide whether or not they would transport him over here, which is what I advised defense before. He also said that we can try to work out the possibility of the defendant giving a virtual plea, but in terms of them releasing him.
But we need a thumbprint. I need a thumbprint. I need his signature.
Yes, Judge.
There's no translator there for him now.
Yes, Judge. He also did say that the officer did also tell me respectfully that we don't really have jurisdiction to litigate this immigration issue.
Sure. What you want is you do not want me to revoke his bond.
That is correct, Judge.
You want me essentially to hold this case open. He's going to get deported, right?
That is my understanding.
Essentially, what you want me to do is you want me to hold this case open indefinitely.
Judge,
This is where the tone shifts hard. The prosecution starts framing him not just as a defendant, but as a risk, flight risk, community danger, prior deportation. And once those labels enter a courtroom, everything changes. Because now the argument isn't just legal anymore, it's about fear and public safety.
I may.
Okay?
Look, to me, for this court to revoke its bond based on these circumstances, I'd like to constitutionalize the objection. I think it would be, a violation of equal protection, procedural due process. I think it would be a violation of Section 11 of the Texas Constitution, which say that all prisoners shall be bailable. Section 13, which say that excessive bail shall not be required. Section 19, which says that no citizen of this state, I don't think they mean U.S. citizen, shall be deprived of liberty, which this would be doing by revoking his bond, without due course of the law of the land. Now, the Texas Code of Criminal Procedure is very clear. When a defendant has once given bail for his appearance, he shall not be required to give another bond. That's 17.09 paren 2. This defendant, all he has done is posted the bond that the state requested, which is in Exhibit 2, which back after the ICE hold, the state requests a $1,000 bond for the defendant. Defendant posted the bond and without any volition on his own gets taken into ICE custody. I think you would agree with me, Judge. The state has the burden to prove a bond violation. There is a bond violation report. I think we should all agree there's been no bond violation because he had no ability to get an ignition interlock. He had no ability to report to pretrial. So the only exception to this one bond are the following. If the bond's defective, there's no defect in the bond. If the bond is excessive, nobody's arguing the $1,000 bond was excessive. If the bond is insufficient in amount, which is very broad, but I want to make clear that there is no amount of bond, as Ms. Saba just said, that can guarantee that my client can attend court. There's no amount. We could set him at $1 million bond. So I don't think insufficient in amount is correct. The only other catch-all is good and sufficient cause. Now, I did some case law research on good and sufficient cause, and these are new or changed circumstances from which the court can conclude that some cause exists for revoking a bond and setting a different bond. Now, as I said, the only bond that this court could set that would guarantee my client comes to court would be a bond that is impossible for him to post, right? Because any postable bond, he would have no control in getting to court. Now, if I may, Judge, I understand what Ms. Saba relayed that the ICE officer said, but I can tell you that 8 CFR section 241.5 allows ICE to release anyone on an order of supervision if they're subject to a final order of removal. If you look at Exhibit 1, the ICE detainer, it says that if you need this subject to remain in the United States for law enforcement purposes, you can call this number at 936-520-5600. 588, oh, sorry, that's the wrong number, 802-020. And ICE can consider whether the law enforcement purposes are serious enough to keep the person in the country.
You can hear how hard this attorney is fighting. Not emotionally, strategically. He's basically telling the judge, my client followed the rules. He posted the bond you approved. So how can you punish him for something ICE did? And honestly, that's the kind of legal gray area that makes these hearings fascinating. Because technically, nobody in this room fully controls what happens next.
I can't show favoritism, right?
Of course, Judge.
If I were to essentially, if he gets deported and I never revoke his bond, where have you ever heard that happening before? Doesn't that show favoritism toward you?
How would that show favoritism?
Because I'm doing something and I'm allowing your client to remain on bond for eternity when I've never done that with anyone else. Essentially, he's on bond for DWI. He doesn't have to comply with any conditions, no matter where he is, whether he's in Abu Dhabi, whether he's in Africa, whether he's in Mexico, whether he's in Guadalajara. You know, he's supposed to not consume alcohol. He's supposed to be monitored. He's supposed to have an interlock. And thereby, I'm saying, okay, here, look, you don't have to do any of these conditions. Everybody else does, but not you, Mr. Moises Perez.
disagree.
You are so...
I disagree, Judge, and here's why. The state of Texas works very closely with the Department of Homeland Security. The state of Texas, if they want to continue him on bond, which is their choice, because they want to continue the prosecution, they don't want to dismiss and refile, they can always put in a request that he be paroled back into the country for the prosecution, subject to the bond conditions. If you don't think that my client wants to remain in the country and follow your conditions, you are incorrect. We requested release from ICE. We requested that he be able to follow the court's conditions and abide by every single thing you put in that order.
You're apples and oranges. No, it's the point is that he's allowed to remain free on a DWI. Everyone else in our court has to follow a certain set of conditions. Yet he's not going to have to follow those.
He should have to follow them.
And Judge,
There's
just
no supervision.
If there's proof
How
of
can I
him,
drug test him?
Judge,
How does he do the
then what's
interlock?
the solution? The solution is either we're
No. I'm going to bench warrant him. But what I'm trying to get you to understand is that it's not fair. I have to be fair to the state, and I have to be fair to you. And I can't show favoritism. And I think that if I were to let him pass indefinitely without revoking the bond, if I were to, we're going to bench warrant now this is theory, right? As a practical matter, I'm going to bench warrant him here for you. But in theory, right, wouldn't it show favoritism? I think it does. Because I'm allowing you and your client to do something that I don't allow anyone else to do.
But wouldn't it be the opposite if you were to take $1,000 from him that he lawfully posted at the request of the state and this court at no fault of his own? I also think that's unprecedented.
I get it, but he's in this country. You know, the right way to do things is you ask for permission, you come here.
Judge, that's completely irrelevant.
Well, no, it's not. You must follow the law, period.
But
And when you don't, there are consequences.
Judge, he was given the $1,000 bond at the state's request
Again,
after we knew he had a final order.
This might be the most important moment in the whole hearing. The judge keeps coming back to one word: fairness. Because courts hate the appearance of special treatment. From the judge's perspective, if every other defendant has to follow strict bond conditions, why should this defendant get an exception just because immigration authorities stepped in? That's the tension here. Not sympathy versus punishment, but consistency versus practicality.
My only concern is that, my biggest issue was that there be no bond revocation. I'm thinking about this logically. If you bench warrant him without a bond revocation, if the sheriff recovers the body, they should have to release the body because he's on bond.
no. He has an ICE detainer. He cannot leave custody. He will continually be in custody from one time until he gets here. At no point are they ever going just to release him in the free world.
I understand, Judge, but what the sheriff is going to say is they're going to say we need a capias. And the capias can only issue if there's a bond revocation.
What leads you to that conclusion?
Because I've seen it in other cases. Or
I will tell you that every time I have bench warranted someone here, we either get them or we don't. I have never had someone released when they have an ICE detainer.
I don't think he'll be released, but I guess my point is, let's say you bench warrant him. He's posted bond already, right? So he gets put in the county jail. He's on bond.
He still has the ICE detainer.
Right, I understand. But when you post bond with an ICE detainer, you can be held for up to 48 hours. So basically, you would be authorizing the sheriff's office to take custody of him for 48 hours maximum, right? Because he already has a bond.
No.
Explain that to me.
His body, and he will stay with us here until we do something with the case.
But his bond isn't revoked.
Correct. I can do one of two things. I can either bench warrant or I can revoke the bond. It is duplicitous to do both. So typically we do one or we do the other. I'm just going to bench warrant him back here. They're going to send the bench warrant to the person at immigration. Hopefully that will expedite the process, but I don't know how long it'll be. But if they bring Mr. Perez back, we should get him back here and we will talk with him the next business day.
Are you able, so the...
I think you're overthinking this, Mr. Feldman.
Judge, I'm looking at the code, right? 1503 gives you the authority to bench warrant, right?
What do you want me to do?
I don't want the bond revoked.
I'm not revoking the bond. I reset the case so as to not revoke the bond. All I did was issue a bench warrant. One, there are two vehicles to get Mr. Perez back here to us. One is a bench warrant and one is a revocation of bond. Both.
At this point, even the courtroom starts sounding overwhelmed. ICE detainers, bench warrants, bond holds, custody transfers. Everybody's talking. But nobody seems completely certain how the process actually ends. And honestly, that's what makes this feel so real. You're watching experienced legal professionals trying to navigate a system that even they admit can become unpredictable.
Judge.
I mean, if you're telling me that you're going to go to the sheriff's office and demand that they release him within 48 hours, I got to go upstairs and talk to a couple people to see how to go forward on this thing. Because I don't know. It's a new one to me, you know?
And Judge, at that point, the state would ask that we revoke the bond, if that's what defense is planning to do. We agree with you.
Then let's just see what happens, Judge.
Judge, we're going to need...
But I have a feeling that you're now going to the sheriff's office to demand his release within 48 hours of recovery.
And Judge, this is putting us in a compromising position as well, because if this is what defense is planning to do, we need to let ICE know. We may need to do that. I need to check with my superiors.
I don't have a problem with letting ICE know.
I don't know what to do here, Judge. I thought we were doing the no revoking the bond as a favor to defense because this isn't customary when we issue a bench warrant. But if defense is going to, in a way, abuse that to get him released, then the state is taking issues with that.
I do too.
Judge, I wouldn't be abusing it.
I mean, if that's what you're going to do, I'm going to end up revoking the bond, I guess, you know, because I don't, I think that you're trying to go behind our backs. It's, I really,
Well,
You know,
Judge, why don't we do this? Why don't we do this? Why don't we do the bench warrant as needed? And if they've recovered the body, then we'll have another hearing, obviously, to figure out what we're going to do. I'm not going to go behind the court's back, but
Mr. Fellman, let me tell you something that, you need to be careful what you do. There is a fine line between zealously advocating for your client and doing something that either breaks the law, is unethical, that could get you in potential trouble. You need to be very careful. You really do. There's a fine line. I've seen a lot of lawyers get in trouble, and I'm just counseling you as, I guess, as a friend, but I guess I get that you're zealous, but just be careful.
Then suddenly, the judge's tone changes completely. This stops being about immigration law and starts becoming personal. That warning to the attorney, that's a judge basically saying, fight hard for your client, but don't cross the line. And you can feel the tension instantly, because now the court isn't just questioning the case. It's questioning strategy, ethics, and intent.
Yes, Judge. I promise you I'm going to follow the code and I'm going to follow the rules of ethics.
I guess, Judge, are you still planning at this point to issue a bench warrant without revoking the bond?
Yeah.
Okay.
Okay.
And then,
We'll see. What happens. We'll see. We'll let it play out. I mean, we're all adults. We'll see how it pans out. You do what you think is right, and we'll just go from there.
okay, Judge. Thank you, Judge.
In the end, nobody really wins here. The bond stays active. The bench warrant moves forward. And everyone leaves knowing the situation could still completely change tomorrow. That's the unsettling part about cases like this. Sometimes the law isn't clean. It's messy, uncertain, and held together by judgment calls.